First, my name is Brian Hill. I work at Baltimore Slow, which is a full-service law firm. We're up to around 60-plus employees. So we cover a lot of different grounds, different areas. But one of the things that we're passionate about is estate planning. And so today, my real goal is for everybody to leave just a little bit smarter about estate planning, particularly wills and trusts. And will and trust is something that we throw around a lot. This is what it means. People think they know what it means. Even attorneys sometimes get confused on the ins and outs of that. But today we're going to just go over those basic ideas, basic definitions. And then afterwards we're going to throw out some general questions, general topics. We'll answer those. And then afterwards, if anybody has any specific questions about their personal situation, I'd love to answer them kind of one-on-one, what fits them. And I will warn you in advance, my favorite answer to any question I always get is something that we learned in our second year of law school, and the answer is it depends. So we might hear that tonight a little bit more, it depends, and that depends on the facts and other situations. And what we talked about tonight is really just for educational purposes. Estate planning can be pretty complex, there's lots of ins and outs. So certainly learn from this and grow from this, but really the takeaway is it can get pretty complicated pretty quick. So always talk to an estate planner or especially a CPA before you do any tax returns. One of the things about our law firm that I like is we have 7 estate planning attorneys in our group. And we have a great staff of people that do a lot of great work. But the rest of our firm specializes in oil and gas, family law, and litigation. And what that does is it brings an additional group of people to the table with knowledge. We can go down the hall and connect with them on issues from family law and oil and gas and get that expertise that other estate planners might not have. So I'm a little biased. I think our firm does a great job, and we have a great skill set for people to pull from. We also do a lot of family law, and that really connects really well with estate planning. Because if we go around this room and we're going to ask people, raise your hand if you're going to die. Raise your hand if you have anybody close to you that's going to die. Raise your hand if you have family. Right? A lot of hands go up all the time. And those two areas really intersect. And so my co-workers and I in the estate planning section really connect really well with our family law attorneys, understanding how what we do impacts them. And we really get a broad diverse involved. So it's pretty good. I really enjoyed that. Also, if you've got an estate planning attorney or one that you're comfortable with, we don't want to take their place. We're not here to outsell them or convince them. Use that estate planning attorney. But if you have questions, we'd love to answer them. If you don't have an estate planning attorney, we would love to fit that bill. I think you do a pretty good job. But certainly, if you have one, hopefully this information that you can take to them to be better when you engage with that particular attorney. So, a trust versus a will. Those two words inside the legal profession carry a lot of meaning, a lot of weight. And we'll probably start with definitions, right? So what is the terminology? You hear these things thrown around all the time. Beneficiary or a devotee or things like that. A lot of those are the same. So the word beneficiary, beneficiaries, legatee, devotees, or even heirs are typically the same thing. And some attorneys prefer one term over the other, but they really mean who's going to get the stuff when it's all said and done. Another term that's thrown around a lot is personal representative. And so we have some attorneys in town who use the word personal representative, some use the term executor or executrix, interchangeable, doesn't make any difference. And sometimes we can get lost on what those mean. So with that in mind, what is a will? Well, everybody in this room, whether you know it or not, has an estate plan. The state of Oklahoma has to determine how my stuff is going to be distributed. And it's a mathematical formula how it works. A little bit to my spouse, a little bit to my kids. And if I want to change that, I need to do an estate plan. If I want to alter the state of Oklahoma's plan for me, I need to do an estate plan. And so a will is a great vehicle, a great tool to use to change their plan. So in short, a will is a written instrument which provides the disposition of your property after you're dead. So in Oklahoma, if you're over 18 years of age and of sound mind, then you can execute a will. It's pretty simple. That standard is very low. So you have to be an adult and have to know who your heirs are. So people ask all the time, should I get a will or a trust? What's the difference? And this is a big discussion. And there's multiple layers in here, and I have my personal biases, and I know that my partners and my coworkers I work with have their biases, but I will try my best to keep those out, right? But a will and a trust, what's the difference? You do not have to be wealthy to need a trust. That's a common misconception. People say, oh, I don't have East Coast money, I don't need a trust, I don't need to do that. Well, that is, some people build up that barrier before it even exists. We don't need to be wealthy to do that. But if you do own a home, or a checking account, or a car, or any kind of asset, you probably need to, you will have an estate, you need to decide how to get rid of those, how do you disperse those. And often a person with a small or modest estate really needs a estate plan. Sometimes we forget about that and say, oh, I don't have much, I just have this or just have that. And they try to discount the value of a will or a trust by saying it's only a checking account or it's only a house. So don't let the dollar amount persuade you down one way or the other. There are several reasons to have a will or a trust, but most importantly, the trust allows you to, a will or a trust allows you to decide who will receive your property rather than leaving the choice to state law. Who's going to receive your property rather than leaving that choice to state law. Having a will allows you to choose who your personal representative is going to be. When I pass away, I almost did it, I said if I pass away, right? So we all know what's going to happen someday. But when I pass away, if I don't have a will, the state decides who my personal representative is. Well, I may not want that. So a will allows me to determine who my personal representative is. Also, the primary benefit for having a trust is it allows you to avoid the probate system. If your trust is created and funded properly, you can avoid probate. And we'll come back to all these things in a little more detail. But equally important, probably the most important for those of us that have minor children, having a will or a trust allows you to name the guardian of your children. If not, you can have various family members show up and have an argument over who wants to be this grandparent set or that grandparent set or this aunt or uncle, and it happens. And a will or trust allows you to be very clear and very specific who you'd like to be named as your personal representative and ultimately be guardian of your children. Without a will or a trust, the court may appoint a guardian, someone that you don't want. And so this planning removes that. Okay, so interestingly enough, I was meeting with a learned professional a couple of months ago, and they misquoted something. He said, oh, if you don't have a will or a trust, does that mean the state of Oklahoma gets your stuff? I scratched my head and I said, what? He said, yeah, if I don't have a will, does that mean all my stuff goes to the state of Oklahoma? No, it doesn't mean that. So I started doing some research on that. That is a common misconception that people have. If I don't have a will or a trust, does the state get it? The answer is no. Oklahoma law provides for distribution of your estate to your heirs. Now, there's a whole bunch of rules about how that works and mathematical formulas about if you're married or if you have kids or stepkids. And I'll spare you the details of that. But suffice it to say that if you don't have a will or a trust, the state of Oklahoma divides those assets to your heirs. But you don't get to pick who that is, and you don't get to pick how that's divided. I would like, during my lifetime, for my wife and I, as we accumulate assets, when I pass away, I would love for my wife to get all of my assets. But if I don't have a will, my wife's not going to get all my assets. There's a formula that it falls through, so spouses don't get everything. And I do have a child. I have 3 good kids. I have 3 average kids. Let me rephrase that. One of them I don't like very much from time to time. It just changes. But if I don't want one of them to get anything, then I need to be very clear in my will and my trust how it happens. Because the state of Oklahoma's determined ownership, they don't care. They all divide those assets up mathematically. And that's really hard to do with a table, really hard to do with jewelry, really hard to do with a house. Not with money, it's a little bit easier. You can get in, think about your assets inside your house. Think about the assets inside your parents' house. Am I really going to divide up mom's jewelry or grandmother's jewelry or this table or my favorite cooking pans? Am I really going to cut those in half and give each kid? Without a will or a trust, the assets are just divided mathematically, and it creates a lot of problems.
So I have a quick question.
No, great question.
Sorry, so what happens if the assets have a loan, let's say the house, and the person dies?
Right. So if we
It's the loan.
right, well, the loan is secured creditor, and so they're going to get paid off first, right? And so a lot of times inside like a mortgage that we're asking about, so inside most mortgages, when someone dies, it triggers a clause, meaning that the mortgage has to be paid off. And so that requires either the estate coming up with cash to pay the mortgage, or the selling of the house that is mortgaged.
Okay, what if this is happening to me right now? So my mom died, and she has a will, so the house still has a mortgage, so my dad continues to pay on that.
Right.
So,
Yeah, that's a great question. We hear that a lot, and I want to answer that question. And so, can I answer that one-on-one when we get through this? Okay, I will answer that, and it's great, and I want to get that. But a lot of those, there's some facts inside there that I want to understand better before I kind of point you in the wrong direction.
no worries. Thank you.
No, but I'm glad that you asked that. And so the next question that I frequently hear is, may I dispose of my property however I want to with a will or a trust? And the answer is pretty much yes. Now, there are, inside a will, we have to be very careful when a will is drafted, because a spouse can take a spousal election, or has a right to get assets out of the estate or out of the will if they're not clearly stated inside there. And so you have to be very careful. There's some very technical pieces inside a will or a trust that will ensure the spouse gets something. So you can't just dispose of it however you want to. A will has a lot of technicalities, and you have to be very careful inside that the way you draft. And sometimes with a will, where people get into trouble, it's not what is said, but what's not said. And without an experienced attorney drafting a will or drafting a trust, we may say, hey, when I pass away, I want all of my baseball cards to go to my one son. If I never mention my other son, I've now created a problem. And so underneath the will, that son may be determined to have a right to those baseball cards. So I have to be very careful in how I draft that. And sometimes, again, it's not what's said, it's what's not said inside the will, especially. I get these questions a lot too. Can I change my will? Can I change my trust? And the answer to that is probably. A will can be changed almost every day, right? If you wanted to redraft a will each and every day, yes, you can change it. There's nothing permanent about a will. So can I change my trust? It depends. And that's one of my favorite legal answers. It's very frustrating. If it's a revocable trust, then I can, because that's the word. I can revoke it anytime I want to. I can revoke the trust I've done. So that means I can change it. I can give my baseball card to a different kid, or to a charity, or whoever I wanted to. I can revoke that. There's a type of trust called an irrevocable trust. That's some advanced estate plan issues, and probably won't see those very often, but that's one that once the ink is dry, we cannot change it. It's an irrevocable trust. Okay, and so now we talked about some of the philosophies of it, some of the concepts of it. Now we get down to money. We're talking about estates. How much does it cost to do it? Does it cost more to administer an estate with or without a will? Well, again, the answer is it depends. So when you have a will, your estate is probated in court. If you do not have a will, your estate is administered in court. And so when you go through this process, you could have you remember, when you draft a will, it costs money to draft it, right? Typically, wills aren't the most expensive estate planning technique out there, but that is a cost. And so drafting without a will is certainly cheaper. But then you get into the prospect of arguing who gets what. And we have a litigation arm in our group, and they do a great job. But I will tell you, when the litigators get involved, it can cost to be very expensive. And so dying without a will can sometimes bring out the most tension, the most strife. There's sometimes the greed in people that you don't always see. You don't see it until it's happened. And without a written set of instructions, and I hear this all the time, my mother said I could have this car. My dad said I was going to get this. And my answer to them is, I believe you. I believe you that your dad said that. When my dad passed away, he said, Dad, he goes, I want you, Ryan, I want you to have my fraternity stuff. Great. But no one else heard it. And so without that document, without that documentation, it's just nice words. So without a will, it can become very contentious very fast. As people will show up and begin to be, what if somebody was told? What if my dad told me and my brother? We could both get that peace. We're both right, and a court has to decide. So ultimately, it's my personal opinion, dying without a will probably costs more money because people's expectations are not set. And people show up expecting that they're going to get everything. I was mom's favorite, or I was dad's favorite. Or I stayed with mom and dad while they were sick, and you were off in California doing whatever, so I should get paid more. Well, there's not a single line in the statute that says that. There's not. It doesn't work that way. But we want it to because we come to the table with our own sense of right and wrong. Plus, we may love or hate our siblings. And we may try to right 30 or 40 years or 50 years of right and perceived wrong in the probate process. The judge could care less. It's just all about math. Give me the assets, get the assets out the door, and get it wrapped up. But when people do that, it just gets ugly. And so one of the things I hear people say is, well, I don't want to have the money to spend on drafting a will or a trust. It costs too much. And I get it. If there's a cheap person in this room, it's me. I mean, I'm the cheapest guy there is. But I understand sometimes the value of putting oil in your car is better than not doing it. It's a cheaper way to go down that road. So, does it cost more to administer an estate with or without a will? It's my opinion, probably without a will is more expensive. But even with a will, it can become really challenging because you have people showing up. And it's not always the kids or the family, sometimes it's the in-laws that create some of the most drama. So, it's really hard. Through that probate process, and our office does a lot of probates as well, so we see the impacts of people not doing the plan. An experienced probate attorney can help you navigate this in advance before you have to get contentious, before it gets ugly. But even then, somewhat their hands are tied because the probate statute is fairly rigid how it works.
One question,
No,
sorry.
great.
So if you have to go through probate, do you have a certain period that you have to file for probate? Or can it just go on and be left alone for a while until things calm down?
So period of time, yes. And there is, you don't have to do it instantly the next day, the next week, the next month. But you should probably within the first, when someone's emotionally ready, they should file. And so if there is a debt out there especially, then yes, you need to get that filed in time. And so again, I'll answer that a little bit more clearly, specifically, just a little bit. So how do I make a will or a trust? Using a will or a trust for a computer program is something we see all the time. Or I'm going to be cheap and I'm going to download a Staples form, or maybe from Zoom Ball. It's only going to cost me $50 or $100, and I'm good. Don't do it. If anybody can do save a dollar, I would do that in a heartbeat. It doesn't work. Oklahoma's a weird state. It's really weird. We have this really weird system where we have the two bookends for wills. One is a very, very informal process called a holographic will. And that is all, I'll pause for effect, all handwritten and signed and dated. The other weird thing about Oklahoma is we have the very, very, very most formal, strict type of will. It has attestation clauses and witnesses and all these words that have to be inside there. Some states allow middle ground. Oklahoma does not. And so what you see is people will download this form and they did it for $50, or their neighbor got it to them, or they scratched out an old form and changed it. It doesn't work. Because the court can either read the handwritten or can read the typed with the attestation clauses. It can't read both. And so you have judges stuck in the middle, and that's thrown out ultimately, and they were going to die intestate without a will. So don't try to save money on downloading a form from Staples and trying to use that as a will or a trust. It doesn't take long for an attorney to sit down and go through a design meeting to build out your beneficiaries. Some people say it's the money, and I get that. Other people say I don't have time to do that. But we do design meetings frequently. Sometimes those design meetings can last from 30 minutes to a couple of hours, depending on the complexity. So the time really should not be a barrier to creating an estate plan, because it saves a lot of time and energy at the end. So what about a handwritten will? We talked about that. Oklahoma does allow entirely handwritten wills that are signed in date. They're called holographic wills, and you can do one each day if you wanted to. But make sure, again, it has no typing on it if you were to do a holographic will. I don't recommend a holographic will. It is a will for people that, I think the motive for the state was, we want anybody to create a will at any socioeconomic level, or maybe on their deathbed or something like that. So we gave this provision. But again, if I leave all my baseball cards to my son, it's the only thing I say in my will. And my other child has a classification called pre-terminated heir, and by omitting him, he now has a right to baseball cards. So it's not what I said in there, it's what I didn't say. So my point in that is to scare everybody away from doing a holographic will. It does serve a purpose, it does work, but it should be used as a last resort. And when we talk about will, sometimes we hear the phrase living will, we hear the last will and testament. So what's the difference? A living will is sometimes called an advance directive. Sometimes people will call it the pull the plug document. They talk about this is what you do to pull the plug. It is not the last will and testament. It's a separate document. But the term will in there throws people off. So an advance directive, it gives you, like, if you have a terminal condition or you become persistently unconscious or have end-stage condition, you may direct that your life not be extended. And so that's a different thing. A living will is different than a last will testament. And so now, for the last part, we're going to shift a little bit to the benefits of a trust over a will. So I'm a little bit biased. I tried really hard on my notes not to be biased, but I think a trust is better. And for a variety of reasons. But a revocable trust is a living trust, or a living trust is a written document providing for the management of your property that becomes effective while you're living. So a trust becomes effective while you're living, unlike a will, which takes place at your death. So let's say that I have a trust, and I've signed it today. As soon as that ink is dry, that trust, and once it's properly funded, and that's a whole other subset, funding the trust. But once that trust is done and funded, that trust, that playbook, that is the handbook of how to manage my assets. And it's effective immediately. If I do a will, on the other hand, and I don't have a trust, that will only becomes effective when I'm not here anymore. Right? So a will only becomes effective at my death. A trust should be, a revocable trust probably is effective as soon as I've drafted it and funded it. A trust is set up for a trustee to manage your property for your benefit during your lifetime or in the event of your incapacity. Listen, each day we get older, each day we're closer to that sad day when our will matures. It's going to happen. And as science progresses, it's more likely we're going to be incapacitated. It's more likely that we are not going to die instantly, right? Maybe you're on a ventilator, or maybe you're comatose, or maybe you're sick and you're going to get better. But when you're incapacitated, who's going to be in charge of your stuff? Who's going to manage your assets? And right now, I want everybody so far has been thinking like this. So I'm going to ask everybody to think about their family right now. Think about your parents, your siblings, your aunts and uncles. Who is going to take care of their stuff when they're incapacitated? Who's going to pay their bills? Who's going to file their taxes? Right? Who's going to take care of? Who's going to keep that machine running? Who's going to go to the bank for them? A trust is a very effective way to allow somebody to be the steward of those assets during incapacity. Now, also, in addition to letting somebody step in when I'm incapacitated, a trust is the same vehicle we use when I pass away. when I die, that trustee will step in and have that same charge, that same fiduciary duty, and that's a very high standard. That same fiduciary duty to make sure my wishes are carried out. We had a sign meeting a couple months ago, and our client could not understand why. What kind of power did that trust document have? She couldn't understand why the trustee was going to do everything that she had set out. It's like, she just couldn't wrap her mind. She was, it's just a piece of paper. What is it? And the way the trust works, the hook of a trust, is when you're a trustee, and by the way, if you have a sibling you don't like, name them trustee of your trust, because that's a non-fun job. If you have a hook for that, is if the beneficiary can charge the trustee with breach of fiduciary duty in the court system if the trustee does not carry out the wishes of the person, of you, if you draft the person that drafted that trust. Here's what I mean by that. If I'm trustee of a trust, and my mother passes away, I'm trustee, I'm supposed to manage my siblings, and I just hoard that money inside there, and I don't do my job, I don't follow the instructions, I can be held personally accountable for breach of my fiduciary duty. That's the hook. And that is a very painful, very expensive hook to breach of fiduciary duty. So the trust has powers inside it. Statutes give it powers more than just the written word. It's the court system behind the beneficiaries, supporting the beneficiaries to ensure that trustee is carrying out the duties. Now, 99 times out of 100, it works great. I name my wife as trustee, then after that we may name another trusted advisor, and we trust them, we vetted them, we feel comfortable with them, they're going to do their job and it's going to work out smoothly. But if they don't, this document, the trust document, has a lot of power built inside it to ensure that works. And it should give us peace of mind. When we sign our estate plan, and we're done signing that, it's going to go the way we want it. It's going to be the playbook.
Can you have more than one trustee, or is it only just one?
Yes.
Yeah.
You can have more than one trustee.
Okay. So like if you have a family situation, you could name multiple, like maybe one or two siblings,
Sure.
just so that one doesn't have to do all of it? I didn't know.
Great question. Absolutely fantastic question. Because yes, you can have multiple trustees.
Okay.
And that can provide protection to make sure that one trustee is not
Lording over the others.
or going off,
Okay.
deep in or not doing anything that provides that. It's a trade-off. The trade-off is sometimes with that checks and balances come lack of expeditious and slow down. If my brother and I both have to agree on where we're going to eat dinner tonight,
Gotcha.
much less how we're going to distribute the house, it can slow down. It's not a bad thing. It's just a trade-off. And the more cooks you get in the kitchen, sometimes the slower it goes. But it's not bad. It's not bad. And you can build in other different types of really specific language to ensure that they move along.
Okay.
And with some advanced planning and stuff. But great question. Great question. Okay, let's see here. And did you have questions here? Okay. So again, when I die, because it's going to happen, right? You just have to get used to that. So my mom is still alive, and it's coming. And my sister has special needs. One of my brothers and I get along great, the other doesn't. So this is a test case. We live inside this thing we all do right now. And so when my mom passes away, it'll be the trustee's job to follow the trust. And the trust can be drafted in a variety of ways. Probably the two primary ways are, as soon as my mom dies, all of her assets are going to go outright to the kids, right? Probably that really means, realistically, in a handful of months, those assets will be distributed. The other way, the other probably major way trust can be administered is that when my mom dies, the assets stay in trust. And the trustee is in charge of those assets to follow specific order. And so that's where it starts to get a little more complicated. When we draft our trust, you can draft the trust where it goes outright to the individuals. Or it can stay in trust for individuals to be distributed under certain parameters. Or it could be a combination, right? You may like one of your kids a whole lot and say, here, you can have it. Half of it. The other one has to stay in trust to be administered under
Is
certain
there a timeline on that? Or is that dictated by the trust?
It depends.
on the
How
state.
about that? That's right. No, well, so in really going, you bring a great question, I think, about getting an attorney involved. If you have a will and you go to probate, you're going to be in the court system, you really need to have a probate attorney walking you through that. So again, a trust does not require probate, does not require the court system. A will does require going to the court to have a probate, and that's more expensive. When you're looking at the total cost of an estate plan, a trust is arguably much cheaper than doing a couple $100 will and then going to the probate process. A trust, for various prices, and I encourage you to ask the attorney the price, understand why the price is what it is. But a trust is more of a one-time fee. You don't have to go, if it's properly funded and all the work is done correctly, it's very unlikely that you'll ever have to go back to court to distribute those assets in a trust. So I have a trust. I'm going to make darn sure my mom has a trust because I don't want to go to probate with my family.
So what if you have a will currently?
Can you draft a trust?
Yes.
Yes, 100%. Yes. And so you could revoke that will and say, I'm going to put a new will in place, or I'm going to use my primary vehicle is going to be the trust that distributes my assets. So most people do have both, and they just never use the will.
Okay.
Do most trust plans come with a will? Like you're talking about?
Yes, that's a great question. Yes, I would think any trust plan worth its salt would have both. It would have a trust and a will. Hopefully, if we do our job right, if the attorney does their job right, you don't have to use the will, right? Because the will is only used if asked that the trust is not properly funded. And that kind of gets into some more advanced planning, advanced concepts of a trust is kind of like a bucket, a box. And we can build, any attorney or estate planning attorney can draft that for you, build that for you. The most important step that's frequently overlooked is putting assets in that box, and that's called funding the trust. And without that funding step, you have an empty box. So that's a great question. Most estate plans come with both.
What do you mean by this?
Just that funding aspect.
So like the bank account
Yes,
is no longer my personal bank.
right.
It goes into a trust.
That's exactly right.
Or the property, like personal property? Goes
Personal
into
property is a
the
little
trust.
bit different, yes, and so personal property should be put inside the trust, the
So
memorandum.
deeding it kind of thing.
But, well, personal property doesn't have a deed, but like real estate does.
Right.
Title, car, real estate, checking accounts, investment accounts,
Okay.
life insurance, probably life insurance should be transferred, the title is the name of the will. And so, are there any advantages to just having a will over a trust? I'm personally biased, I don't think so. But I guess the one thing there could be in there that is cheaper up front, it's probably the only benefit I could come up with having a will versus having a trust, is arguably cheaper up front. In the long run, I don't think it is. But a will is a perfectly valid estate vehicle. It is a good way to get assets from one generation to the next. And you have the court involved. The court makes a final decision, and when that gavel falls, ownership is divided, and it works. It's worked for generations, and it will continue to work for generations. A will isn't bad. A will isn't something that shouldn't happen. I just think that a trust is a more elegant solution for handling people's estates. But the only benefit I can think of to a will is it's just probably a little cheaper up front, but in the long run, so one thing, we're almost done with this, and we'll kind of get some general questions. Are there other alternatives to a trust or a will? The answer is yes, but beware, right? We transfer on death, payable on death. Those are tools that people can try to use as a replacement for an estate plan. So you primarily see those like on my checking account. If it's my checking account, I sign a piece of paper with the bank that says, when I die, give this money to so-and-so. It's a transfer on death. Here's the hook. I don't know what that piece of paper says. I don't know what it means, and I don't know if they're going to honor it. So I'm putting a lot of faith in that finance institution that they're going to get it right. And so I want to caution people to be careful on transfer on death or payable on death provisions.
So my goddad just did that, and he was trying to tell my dad that that's what he needed to do, that he filled out a piece of paper, or did some kind of paper that says, when I die, the house is to go to my son.
Right. So that's for transfer on death deed, and that is a tactic that people use to avoid that. But if there's a loan on the house or anything like that, it can become challenging to go through that. But that payable on death, that transfer on death, you can do it with vehicles, you can do it with real estate that's wholly owned, without a loan, and you can do it on checking accounts and other things.
What about mineral rights? Is that considered personal property in
That's
Oklahoma?
considered real property.
It's considered real property.
What if the person that you named is no longer alive?
Exactly. And so at that point,
Then it goes to probate then?
yes, it would go part of your estate. And since you're not here to transfer ownership,
Yeah.
it's now considered an asset of your estate, and it goes pursuant to your will if you have to. So without those additional steps inside there, transfer on death, payable on death is a tactic people use, but it is not without risk, because there's a lot of what ifs in there. And estate planning attorneys spend a lot of time going through and making sure those what ifs are covered, right? Here's one I hear a lot. Is joint tenancy a substitute for a will or a trust? My answer is no, it's not. I'm a little biased again, but joint tenancy would be in Oklahoma. My wife and I own my house. Joint tenancy with the right of survivorship. If I pass away, my wife then owns all of my house completely. So that's a tactic that my wife and I use to own our house together, but it is not a very effective estate planning tool. People will say, oh, I don't need a will or a trust because my house is held in joint tenancy. What about my wife? She needs an estate plan. What if we die in the same car accident? Now we have to probate that, right? Now we have an asset that's not properly funded. It is probably someone trying to take a shortcut, not doing their homework to get it all done all the right way. So again, joint tenancy is arguably not a substitute for a will or a trust. Upon the death of the first joint tenant, the property passes to the survivor, and the survivor has to do estate planning, and we hope the survivor really does survive. Of course, we've got issues. And last but not least, I own property in another state. What do I need to do? When you have owned property in another state, you can easily open an ancillary probate. But each state has its own laws that they respect or give credence to other states' probate process. So if you own assets in another state, you still need to title it in the name of your revocable trust. And I would encourage you not to rely on the probate system for that. It's just longer and harder, and you have to also go through the second states.
So the state of Oklahoma, like if you had property in Arkansas and you titled it in your trust, where does it go? Like
Your trust would own it.
the trust would own it. So
Yes.
upon your death, it would be a part of the
That's
trust.
exactly right. It would be all, it would all be an
So it doesn't
asset.
have to go through that state's probate
If
process.
it's titled correctly,
If it, okay.
titled correctly, then yes, it should pass through, it should go, it's how the normal trust process.
Never thought about it.
We have it all the time, if someone's,
I know you all
an aunt or
do.
uncle passed away with minerals,
Okay.
in Oklahoma or sometimes in different states. it happens.
Okay, gotcha.
So that's really it. I know we covered a lot of nuance, a lot of things to think about. Any general questions? I know we've kind of done that in a little bit, but I want to be able to make sure we're answering it. And I have Kristen Mugg is in the back. If there's anybody in this state that knows more about estate planning, I can't find them. So any question I can answer, she knows what's going on.
So I have a general question. So when an estate planning attorney works with someone that's doing a trust, is it generally just, like, let's say it's a mom and a dad and they've got kids. Is it just the mom and the dad, or do you normally see like the family coming together going, this is what our vision for what we want together? I don't know, like ethically, what do you do? Or how do you do that?
So ethically, that's a tough one,
Okay.
right? We have to make sure that we do represent both settlers, both renters,
Okay.
and understand there's a conflict. We have to, about how it operates for labor, get them to waive that conflict.
Okay.
But bringing kids in or bringing heirs in is an effective way to maybe get family communication going, and get everybody on the same page, then avoid that. Kristen, in your experience, what's your thought on that?
Well, going back to your favorite answer, it depends, right? I mean, I think the clients are mom and dad and not the kids. And so you want to be really clear that your clients are mom and dad. If they want to bring the kids in and have their input or have them involved in the process, I mean, it's really helpful for them to know what to anticipate, especially if, well, this one's going to be the trustee and they're not, and so here's how that works. And so I don't want the kids to be overly influential of mom and dad and start acting like it's their stuff and they get to make the decisions. And so that's why I say it kind of depends. But at some point, bringing in the next generation so they know what to expect. As you go back to that, grief and surprise and shock, and if things are not what they expected, then you're kind of anticipating drama. But yeah, so that was kind of it.
No,
does-
I mean, it makes
yeah.
sense, it makes sense.
How common is it for parents to bring kids in for that discussion?
I had that. For me personally, I would say relatively low. A lot of times parents, and it's weird, some people, we talk about a lot of stuff in this country, we don't like to talk about money, right? There are some families that will say, there will some families that parents will say, our kids don't know how much we have in the bank, and they're never going to know until we do. Okay, or our kids don't know that we have this other, house or these other assets, and they're just never going to know. Some families are more open about that, and so it's usually pretty low in my experience. There are families that don't get along at all, and you can tell that. We talk to them, and I tell them there's no reason you have to share this plan with your kids if you think it's going to make everybody angry. Just wait till you're not here, then let the next generation deal with it. But it's just really setting those expectations. Generally, I think if it's complicated with businesses and all those different assets for family farm, those things, I think communicating, doing the plan, and then sharing the plan after it's done with the kids is probably the most effective. Okay, any other general questions? I know you've got a few specific ones. Okay, I'll answer them. No, that's great, so I think that'll be it. And listen, we would appreciate everyone taking time out of your day to come visit with us. Whether it's anybody in this room or any of your family, because you spent time with us, we would love to offer a discount. So if you guys want to use our services today, or if you have a family member that want to do this, talk to me or Josh afterwards, and we'd love to write your name down and just extend that discount on to immediate family members for you guys, because we just appreciate you coming to spend some time with us. So thank you guys for this. Appreciate it.